Supreme Court has just issued a shocking 5-4 emergency order, and it's sending political and legal shockwaves across the nation. In a rare split decision like this, every single vote matters, and tonight, that one deciding vote could alter the balance of American law. Emergency rulings of this kind are almost never this divided, which makes this one all the more explosive. Why did the court act now? What triggered such an urgent and deeply divided response from the justices? And most importantly, what does this mean for your constitutional rights moving forward? Stay tuned, because the fallout from this late-night Supreme Court order could change everything we thought we knew about justice, power, and the future of the Constitution itself. On August 21, 2025, the Supreme Court released an emergency order that divided the justices right down the middle on two separate but related questions. By a vote of 5-4, the court granted the Trump administration's request to pause a federal judge's ruling that had required the National Institutes of Health to continue funding research grants linked to diversity, equity, and inclusion initiatives, as well as studies on COVID-19, transgender health, and health disparities. Justice Amy Coney Barrett provided the key vote, joining Justices Clarence Thomas, Samuel Alito, Neil Gorsuch, and Brett Kavanaugh to allow NIH to terminate the grant. But in a separate 5-4 split on a different portion of the same case, Barrett switched sides, joining Chief Justice John Roberts and Justices Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson to leave in place the lower court's ruling that threw out internal NIH guidance documents. This was not a full ruling on the merits. This was an emergency stay, a temporary order with enormous short-term consequences for hundreds of scientists whose research funding disappeared while the legal battle continues. This case began in late January 2025 when President Trump signed a series of executive orders targeting what his administration called radical and wasteful government DEI programs. One order was titled Ending Radical and Wasteful Government DEI Programs and Preferencing. Another was called Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the Federal Government. In response, NIH ended hundreds of grants covering research topics the administration deemed politically charged, including studies on vaccine hesitancy, HIV prevention, transgender health, health disparities affecting minority communities, and even some COVID-19 research. As many as 2,300 grants were terminated. Scientists, researchers, university systems, and advocacy groups immediately went to federal court in Massachusetts, arguing the terminations violated both the Constitution and the Administrative Procedure Act, the federal law governing how agencies must operate. District Judge William Young agreed with them in June, ruling the grant terminations were arbitrary, capricious, and illegal. He ordered 848 grants restored, stating he had never seen government racial discrimination like this in his 40 years on the bench. But the Trump administration appealed, and when lower courts refused to pause Judge Young's order, they came to the Supreme Court seeking emergency relief. The drama of this decision centers on Justice Amy Coney Barrett, who became the swing vote on both questions before the court. On the first issue, whether to allow NIH to stop funding the terminated grants, she joined the 4 conservative justices to grant the government's request. But on the second issue, whether the district court had authority to throw out NIH's policy guidance documents, she flipped and joined the 4 more liberal-leaning justices and Chief Justice Roberts. This created 2 separate 5-4 splits in a single case. The conservative majority argued the district court in Massachusetts didn't have jurisdiction to hear the case at all, citing a recent precedent involving Department of Education grants. They said contract disputes over federal grants must go to a specialized court called the Court of Federal Claims in Washington, D.C. But Chief Justice Roberts, in a rare break from the conservative bloc, argued this case was different because Judge Young had thrown out the guidance documents, which goes beyond just reinstating specific grants. The ideological tension was palpable. Justice Gorsuch, joined by Kavanaugh, wrote that lower court judges may disagree with Supreme Court decisions but are never free to defy them. Meanwhile, Justice Jackson fired back with her Calvin Ball reference, accusing the majority of having only two rules: no fixed rules, and the administration always wins. Even though this is technically a temporary emergency order, legal experts say it effectively ends any hope these scientists have of getting their grants reinstated. Here's why. The majority said the case must go to the Court of Federal Claims, a specialized venue for contract dispute. But here's the catch. That court has no authority to order grants reinstated. It can only award monetary damages after years of litigation. So the Supreme Court is essentially telling these researchers, you're in the wrong courtroom, go file in a different court that can't actually give you the relief you need. Constitutional law professor Samuel Bagenstos, who served as senior lawyer in the Department of Health and Human Services under President Biden, explained it bluntly. The Supreme Court is going to deny you the remedy of getting your grant reinstated and send you to a different court where after potentially many years you might possibly get some damages, but you won't get your grant reinstated. This isn't just a procedural step. The reasoning the justices gave for putting the district court's injunction on hold makes clear their view that this case shouldn't proceed at all. When the full case eventually reaches the Supreme Court for final judgment, this emergency order is a preview of how they'll likely rule. The reaction was swift and furious from both sides. The Association of American Medical Colleges released a statement calling it the wrong choice for the nation's future, declaring that history will look upon these mass research grant terminations with shame and accusing the court of turning a blind eye to this grievous attack on science and medicine. They called on Congress to take action to restore the rule of law at NIH. Scientists took to social media expressing devastation. Greg Gonzalez, an epidemiologist at Yale University, wrote that grants ripped away on dubious grounds, restored by a reasonable judge, are now again terminated by an out-of-control Supreme Court, warning that labs will shutter and people will lose jobs. Environmental epidemiologist Scott Delaney, who maintains a database of canceled science grants, called the decision atrocious. On the other side, supporters of the Trump administration's position celebrated what they see as a victory for ending taxpayer funding of ideologically driven research and restoring presidential authority over the executive branch. They argue the administration has every right to set funding priorities and end programs it views as wasteful or discriminatory. The American Civil Liberties Union, representing some of the plaintiffs, called the ruling a setback for public health but vowed to continue fighting, saying they would assess their options and work diligently to ensure unlawfully terminated grants continue to be restored. For ordinary Americans, this decision's impact extends far beyond academic politics or DEI debate. The terminated grants included research on vaccine hesitancy at a time when public health officials are concerned about declining vaccination rate. They included HIV prevention studies that could save lives in communities disproportionately affected by the epidemic. They included research on health disparities that explain why certain populations suffer worse outcomes from diseases like diabetes, heart disease, and cancer. Justice Jackson spelled out the human cost in her dissent. Years-long studies will lose validity. Animal subjects will be euthanized. Life-saving medication trials will be abandoned. Countless researchers will lose their jobs. Community health clinics will close. The forward march of scientific discovery will not only be halted, it will be reversed. For graduate students and postdoctoral researchers whose careers depend on these grants, the decision means immediate job loss and uncertainty about their future in science. For universities that had budgeted based on these federal funds, it means scrambling to cover costs or shutting down labs. For patients waiting for clinical advancements from this research, it means delays that could be measured in years or even the complete abandonment of promising treatments. So what happens procedurally next? The case now moves forward, but the path is deeply fractured. The Supreme Court's emergency order essentially directs that claims about the grant terminations themselves must go to the Court of Federal Claims for contract dispute litigation. That process could take years, and as legal experts point out, that court cannot order the grants reinstated even if the researchers win. Meanwhile, the challenge to NIH's guidance documents can apparently remain in district court under the Administrative Procedure Act. But even if the scientists win on that front and the guidance is permanently invalidated, it won't automatically restore their terminated grant. Justice Jackson called this a deeply inefficient and likely impotent scheme of judicial review. Legal observers are also watching another case closely. University of California faculty filed a class action lawsuit in a different district court and also won an injunction in June ordering restoration of grants terminated by multiple federal agencies. The government is making the same jurisdictional argument in that case, and many expect the Supreme Court will issue a similar stay there, effectively shutting down that avenue of relief as well. The broader message is clear. Challenges to federal grant terminations will likely be quashed using this same jurisdictional argument, giving the government, as one researcher put it, a very big arrow in its quiver for all of those cases. This decision reveals something profound about the philosophical divide shaping America's future, and it's not as simple as conservative versus liberal. Yes, the vote broke largely along ideological lines, but Justice Barrett's split decisions and Chief Justice Roberts' dissent show the complexity at play. At its core, this case pits executive authority against judicial oversight, presidential power to set policy against the rule of law requiring reasoned decision-making by agencies. The majority prioritized jurisdictional rules and deference to executive branch choices about funding priorities. The dissenters prioritized ensuring that when the government acts arbitrarily or capriciously, courts have meaningful power to check that abuse. Justice Jackson's Calvin Ball reference cuts deep because it suggests the court is making up rules as it goes to favor a particular administration. Her claim that the only consistent rule is, "this administration always wins," in emergency applications speaks to a broader concern about the court's emergency docket, sometimes called the shadow docket, where major decisions get made without full briefing or oral argument. The fragility of constitutional interpretation has rarely been more evident than in a case where the outcome literally depends on a single justice's vote on emergency applications with life-or-death consequences for scientific research. Expect the legal battles to intensify in the coming weeks and months. The Trump administration has already indicated it may expand grant terminations beyond the initial 2,300, empowered by this Supreme Court victory. Other federal agencies may follow NIH's lead in cutting funding for research they deem politically objectionable. University systems and state attorneys general are exploring new legal strategies, though this decision has closed what they thought was their strongest avenue for relief. Congressional Democrats have called for hearings and legislation to protect scientific research from political interference, but in a divided Congress, the prospects for such legislation passing are uncertain. Meanwhile, the scientific community is mobilizing. Professional associations are drafting statements, researchers are organizing to document the damage to ongoing studies, and universities are trying to find alternative funding sources to keep critical research alive. Some scientists are considering whether to move their research to private institutions or even relocate to other countries where scientific funding is more stable. The immediate future looks bleak for the hundreds of researchers whose grants were terminated, but the long-term implications for American scientific leadership may be even more significant. When the United States government can arbitrarily shut down research based on political preferences, it sends a message that science in America is subject to ideological whims. A 5-4 decision may sound divided, but the impact is undeniable. The Supreme Court just shook the foundation of federally funded scientific research, and we're only seeing the beginning of the fallout. $783 million in grants, hundreds of researchers, years of scientific progress, all put on hold or permanently terminated while legal battles that may never restore the funding drag on through the courts. Justice Jackson warned that the forward march of scientific discovery would not only be halted but reversed. Labs are shuttering. Researchers are losing their jobs. Potentially life-saving studies are being abandoned. Whether you see this as a necessary correction of government overreach and wasteful spending, or as a catastrophic attack on science and the rule of law, depends on your perspective. Stay informed, stay engaged, and pay attention to what happens next, because this fight is far from over. Like, share, and subscribe. We'll break down every major development as this constitutional crisis in scientific research continues to unfold.